Hello and thank you for downloading HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. Subscribe via iTunes or download via the Taylor Vinters website or YouTube channel. We hope you enjoy the show. Hello and welcome to the latest episode of HR ListenIn. I'm Dom Holmes, an employment lawyer at Taylor Vinters and presenter of HR ListenIn. Now, businesses are giving greater importance to data and its protection given the upcoming legislation, with significant penalties for getting it wrong and high-profile big data breaches. So we thought we'd take the opportunity to have an introductory session drawing on some of the key drivers and developments in the world of data protection. Now, before we do that, just as a reminder, HR ListenIn is available to download via the iTunes platform. So for those of you with iPads, iPhones or other Apple devices, you can now subscribe to the podcast and it will download automatically to your device each month. Simply head to the iTunes store and search for Taylor Vinters. You can also still access individual podcast episodes on the Taylor Vinters website or via the Taylor Vinters YouTube channel. So joining me to discuss what's been going on in the world of data protection is my colleague Razia Begum. Now, Razia specialises in providing commercial advice to our clients on employment and employment-related privacy and data protection issues, both in the UK and internationally. So welcome to the show, Razia.
Thanks, Dom. Hello, everyone. I'm really pleased to be speaking today and to be discussing one of my favourite topics next to travel, of course.
Well, of course. So what are we talking about in this episode specifically?
Well, as you said, there's been some major developments and high-profile cases regarding data. As a starting point, though, especially for those listeners who are not as familiar as some may be with data protection, I want to get the ground running by speaking a little bit about data itself and why its protection is so important. I'd also like to talk a little about some recent and key developments in this area, and finally to cover a topical subject which is close to many HR specialists, and that is subject access requests, and some practical tips for handling these.
Well, I certainly agree, Razia. It seems to be a growing and topical area, and there does seem to be an awful lot in the press at the moment about data protection breaches.
Absolutely. So recent and big data breaches such as Morrison's, TalkTalk, Tesco's, where a significant amount of employee and customer data fell into the wrong hands, should be a stark reminder to us all of the importance of getting it right.
Excellent. Well, shall we get the ball rolling, Razia, and kick off by you explaining to us what data is and why its protection is so important?
Sure, Dom. So data is central to many businesses, particularly in a digital era where data is increasingly centralised and managed digitally. It's becoming increasingly valuable, and if it is not adequately protected by businesses, it could have negative reputational and financial consequences.
Okay, so data is quite a big definition. So when you say data, what exactly do you mean by that?
Well, data is quite a big topic, quite literally, and in its broadest sense, it covers a range of subsets such as personal data, which will be my focus in the context of HR, non-personal data, genomic data, and other forms of information. Personal data, which is my focus, is data which relates to a living individual who can be identified either from that data alone or from that data and other information. So in a HR context, this will include employee data, for example, a CV or an application, or even a performance review documentation.
Okay, and what has been the impact for businesses then with all this personal data flying around?
Well, this has resulted in data protection laws being introduced to protect personal data both across Europe and the world. And it can be a real challenge for businesses to keep up to speed and to comply with these obligations imposed on them. And of course, the increasing scrutiny by regulators and the media.
I mean, there's been a sense that some of these data protection laws are quite toothless in some ways, and I think hence the reluctance by some to take data protection seriously. Is that right?
Yeah, I agree with you. I think in the past there has been some reluctance, if you like, by regulators to enforce. And it can be said that a lot of these regulators have taken a softer or lighter touch approach to breaches, where they've issued minimal fines and in some cases at best only issuing a warning or a slap on the wrist, so to speak, for non-compliance. But there has been a real cultural shift, if you like, in the attitude of regulators, who now seem to be taking a much more aggressive approach to non-compliance, particularly in relation to big data breaches.
Well, that's interesting. So what do you think has been the reason for this shift in attitude?
I think it's down to a combination of factors. Firstly, I think it's the increasing use or misuse, if you like, of the importance and value of data in a digital era. So it's essentially a commodity, if you like, and it's exposed to risks. Secondly, I think it's the run-up to the new and much anticipated General Data Protection Regulation, otherwise known as the GDPR, that will come into force in all the EU member states in May 2018. And that has been aimed at modernising and harmonising the existing legislation across Europe. And finally, I think it's subjects in a very sort of media-savvy, social media time that we're living in. It's subjects becoming increasingly aware and exercising their rights and taking enforcement action ultimately.
Okay, and what's really at stake for businesses here?
Well, in the UK, the regulator, which is known as the Information Commissioner's Office, that's the ICO, they have the power to issue monetary penalties of up to £500,000, together with other sanctions such as enforcement notices and undertakings. And in fact, penalties will soon be higher under the GDPR, with national regulators having the power to impose fines of up to the greater of €20 million, or 4% of the annual worldwide turnover. There's also going to be more onerous obligations imposed on businesses under the GDPR regime. And I think despite Brexit, it seems likely that the GDPR will come into force and when we leave the EU, and the data protection regulation in the UK will in any event mirror or be similar to the GDPR. Therefore, I think the GDPR needs to be complied with.
Okay, well that's really interesting, and certainly some bigger numbers there. And are these enforcement powers by regulators actually used?
Yes, more so than ever. And I think, as an example, the ICO has recently issued a record fine of £400,000 to TalkTalk for its failure to have in place the appropriate security measures to protect its personal data. Maximum fine is £500,000, so you can see it's almost the maximum.
Okay, and then, it seems to me then that actually the legislation is quite powerful given those financial penalties you've just referred to.
I agree, the legislation is powerful and becoming increasingly so. However, I think the real loss for companies is the commercial and reputational damage that's actually suffered. Again, using the recent TalkTalk breach example, although the fine issued by the ICO is the highest ever to date, just short of the maximum of £500,000, it was probably inconsequential in comparison to the commercial and reputational damage suffered by TalkTalk. There was significant negative publicity. There was reported costs of a staggering £60 million and loss of customer loyalty, with the loss of over 100,000 customers, not to mention the separate criminal investigations which are also ongoing.
Okay, well let's now delve into some of the key developments in the area of data protection. So if you could name just a few, Razia, what would those be?
I think there are two major areas, Dom, which have recently sort of come to light, and that is the EU-US Privacy Shield and the GDPR.
Okay, well let's take each of those in turn then, starting with the EU-US Privacy Shield. Now before we talk about how it came about, could you tell us a little bit about sort of data transfers, because that's really what it's concerned with?
Absolutely. So under EU law, personal data actually cannot be transferred outside of the European Economic Area unless the recipient country or territory has what's called an adequate level of protection, and that's for the rights and freedoms of its data subjects. So in an employment context, that would be the employees. So there are several options available to a US recipient, if you like, for achieving what's called an adequate level of protection vis-a-vis the EU, and that includes, until recently, the Safe Harbour framework.
Yeah, so many of our listeners will probably be familiar with safe harbour, and are we now saying that it's no longer an adequate level of protection?
Yes, that's exactly right. So in October of last year, the European Court of Justice categorically held that the safe harbour framework, which had actually facilitated data transfers for the previous 15 years, was actually contrary to EU privacy law. So what this now means is that safe harbour can actually no longer be relied upon to ensure the safe transfer of personal data from the EU to the US. Now, as a result of that decision, the EU Commission promised a new framework that would be introduced to supposedly give greater obligations on US companies receiving and handling personal data from the EU. And at great speed, a replacement was introduced on the 1st of August 2016 called the EU-US Privacy Shield.
Okay, so very interesting, but how exactly then does this EU-US Privacy Shield protect personal data better than the safe harbour regime did?
Well, that's a very interesting question, Dom, and one that's been asked by a lot of commentators, academics, practitioners, and there is a lot of debate about whether it actually does. But in theory, there are stronger obligations on US companies, specifically any company handling human resources data from the EU will be required to comply with the decisions of the European data protection authorities, which often involves seeking consent for the transfer from the relevant staff involved.
Okay, and we spoke a little bit earlier about the enforcement powers that apply particularly in the UK.
Mm-hmm.
Will there be stronger enforcement in the US?
Well, again, theoretically, there is supposedly stronger enforcement in the US, as US companies are now required by the US Department of Commerce, which oversees the certification under the Privacy Shield, to publish their data protection commitments. Now, these commitments can in turn be enforced by and under US law by the Federal Trade Commission, which actually arguably gives the Privacy Shield far more clout than its predecessor. The Federal Trade Commission also has the power to publish sanctions ordered against non-compliant companies, and that's really the age-old trick of naming and shaming.
Okay, so you've spoken about sort of US enforcement agencies and what they do. Is that matched then by stronger enforcement rights at an individual level?
Again, theoretically, under the Privacy Shield, there are stronger individual enforcement rights. And in practice, what this means is that an aggrieved individual under the Privacy Shield will have several remedies open to them. And that will include making complaints directly to their company, to the National Data Protection Authority, and as an addition to a new US ombudsperson, which will handle complaints involving access to data, but only in the very specific remit of national security purposes.
Okay, so we've got this new regime in place, and what's the uptake been like since August when it came into force?
Well, the Privacy Shield has now been active for a couple of months, and under the old regime, that safe harbour, some 4,000 companies operated under it. Uptake to date has been roughly about, I think it's 1,200 US companies and business entities who have signed up to it. And frankly, I'm not surprised given the speed at which it was enforced.
Okay, so clearly quite a number of businesses there might still be operating under safe harbour.
Mm-hmm.
And what happens if they continue to use that rather than the Privacy Shield?
Well, I think businesses that still rely on safe harbour should be very cautious, as they are potentially exposing themselves to sanctions for non-compliance. Remember that under the GDPR, higher fines have been introduced for non-compliance based on percentage of company turnover, which can be significant.
Okay, and if businesses don't want to sign up to the Privacy Shield, are there other options open to them?
So, as well as the Privacy Shield, organisations can also rely on EU standard contractual clauses and binding corporate rules as options for compliance. There is some pending European case law testing the validity of these alternative mechanisms. So we may see a greater number of companies joining the growing list of Privacy Shield organisations. However, I should also mention quite recently there has been some challenge, if you like, to the Privacy Shield and whether it does actually satisfy giving that adequate level of protection. So it'll be interesting to see how things develop with the Privacy Shield.
So clearly quite a lot still up in the air there, and changes that will clearly impact many businesses. Sounds like we're probably having a future podcast on this, Razia, in any event. All right, well, that's the US-EU Privacy Shield. Let's move on to talk a little bit more about the much anticipated GDPR.
Sure. So the GDPR is the first major change to data protection law in Europe since actually 1995. And it will be directly applicable in every EU member state and enforceable from May 2018. Now, it will make, and it's no exaggeration to say that it will make far-reaching changes to the existing regime. And I think as a result, every organisation that collects, processes or stores personal data should be at least thinking about taking some steps now to achieve compliance for the future.
All right, and what are the more important changes then that businesses should be aware of under the GDPR?
Well, I think there are a number, but to name a sort of top few, if you like, which have made some of the sort of major headlines in the press, is probably the introduction of the data protection officers in the larger organisations, and I think that marks a real cultural shift, if you like. Also, this idea of the territorial scope creep, in inverted commas, to quote, which essentially means that UK-based businesses who offer goods or services to individuals in the EU will also need to comply with the regulations. There's also more stringent requirements for valid consent, and I think that's going to be a real issue, particularly in a HR context, which a lot of employers and companies will need to start thinking about. And I think also something that's quite interesting, because it has a real practical impact, is the requirement now to notify data breaches within 72 hours.
Okay, so some quite sort of far-reaching changes there, and certainly I think from my experience, Razia, data protection officers will be a key one as well, because I know certain other jurisdictions, they have those, so Germany, for example, and they really do sort of, scrutinise data protection in practice in those organisations. So I think compliance seems more important than ever, it seems, and you've mentioned earlier the significant monetary penalties for non-compliance.
Yeah, so just drawing on those a little bit more, the GDPR imposed what's called a tiered system of penalties, and that will depend on the nature, the gravity and the duration of the breach. Now, at the very top end, a penalty of up to 20 million euros or 4% of the organisation's annual worldwide turnover, whichever is a greater, may be imposed. I mean, that's very significant. Now, examples of infringement which attract a 4% penalty will include, basic breaches of processing, such as the conditions for consent, and breaches of requirements relating to international transfers of personal data. At the other end of the spectrum, for other specific infringements that are considered less serious, if you like, there's still a penalty of up to 10 million euros or 2% of the organisation's annual worldwide turnover. So you can see there's a real shift and an increase, if you like, on the monetary penalties that can be imposed.
Okay, now obviously the GDPR is a piece of EU legislation. So, in terms of employers in the UK, what's going to become of that in light of Brexit? I mean, is compliance going to be a waste of time for UK-based businesses?
Well, I think compliance, just to answer your question in a nutshell, it's not a waste of time, and it's absolutely crucial that companies take or start thinking about taking steps for achieving compliance under the GDPR regime. I think it's too early to definitively say what the UK's data protection landscape will actually look like post-Brexit. I think you'd agree with me, Dom, that in all practice areas we just don't have that certainty yet.
Yeah.
However, I think for the time being, and this is drawing on the ICO's general guidance, it seems clear that businesses, particularly those operating in multiple territories, should continue to or start taking steps to make arrangements for compliance, irrespective of the referendum result. And I think this is backed up by the fact that the 2-year Brexit withdrawal process, which is the approximate time frame, once Article 50 is triggered, will be likely to be finalised after the GDPR becomes enforceable in May. So GDPR will come into force before, I think, Brexit. Also, UK-based businesses who offer goods or services to individuals in the EU will, I think, in any event, need to comply with the GDPR by virtue of the introduction of the territorial scope creep, which I spoke about earlier.
Okay, interesting. And so, I guess one other question I have is, what are other EU member states doing at the moment?
Well, progressive steps are being taken by other EU member states in order to meet the requirements of the GDPR. Therefore, the UK risks, if you like, losing its safe data status if it fails to upgrade its data protection laws, which actually fall in line with the rest of the EU. And I think at the very least, certainly my view is that the future of the UK's data protection landscape will require careful consideration in order to ensure that UK businesses, from a financial, commercial, practical point of view, are not actually put at a disadvantage, if you like, because it will, in order for UK businesses to flourish, one of the things is it needs to have a similar standard, if you like, to how it handles data.
Sure. Yeah, well, all very interesting. Again, it's certainly something we'll be keeping tabs on over the coming months. Okay, so Razia, just as a sort of a final piece in this podcast, for our HR specialists who might be listening now, HR practitioners often come to us seeking advice on tricky subject access requests made by employees, don't they?
They do indeed, Dom, and subject access requests, or shorthand SARs, are often used for strategic purposes and often as a tool in disputes between employees and employers. And I think also with the vast technological developments, it also means that actually SARs are now potentially far broader in scope than was previously the case.
Okay, so just briefly then, what practical tips would you give to HR specialists who receive one of these SARs and have to navigate them from start to finish?
So I think as an initial sort of starting point, if you like, what's key is that the employer or HR act reasonably throughout the process. So it's always good to have that sensible, common sense approach hat on, if you like. As a sort of starting point, I'd also say that you shouldn't feel overwhelmed by it, and I think it's crucial, just as a sort of initial step, to check that the basic things like the request is in writing, that you have the correct fee under the current regime, which is £10, that the request provides as much information for you to locate the data relating to the employee. For example, asking for any further information which you require. So it's really getting those initial steps, if you like, checked off. Another point I'd say is don't be afraid to negotiate with the employee. The Data Protection Act allows you as data controllers, i.e. the employers, to negotiate, have a dialogue with the employees to get the employees to specify the exact information that he or she wishes to receive.
Okay, and are there any sort of tactical considerations that might be helpful for an employer to consider? Say, if, for example, they're under time pressure.
Certainly. I think before agreeing the 40-day time limit, which has started, there is scope to delay actioning the subject access request until the employee has been sufficiently clear as to the information which has been sought. So this can include, for example, asking the employee to be more specific as to the type of information sought, any relevant dates, or any of the relevant individuals concerned. Now, the time limit is not triggered until the employer has actually sufficient information to begin that search. So this delay can really be critical if settlement discussions are underway, and to avoid giving the employee ammunition, if you like, to argue for a higher severance package. Also, narrowing the scope of the search can reduce the time and cost spent on the search itself, which can be considerable, particularly when searching through, say, deleted emails or servers held by third parties.
Okay, that's great. Any other top tips on that?
Yeah, I think, you can keep the employee informed, and that will include sending them an initial response, if you like, indicating the time at which you expect to fully respond, noting, of course, that the 40-day statutory time limit. In terms of the data, it's about locating the relevant data, backing it up, checking anyone else who may be processing the employer's data, so external payroll provider. And although I think, just as a point to mention related to this, there may be a temptation and a natural one to change any relevant records. You shouldn't do this even if they are inaccurate or embarrassing. Okay, just in terms of some other tips, you should be mindful to check if there's any exemptions which apply to the data, such as legal privilege or data relating to other individuals or third parties, or data relating to management planning, because these will all be valid to be used as a reason for not handing over that data. And finally, when you're responding to the employee, I think it's important that you provide the relevant data and explain any exemptions you rely on, so that you can justify why you haven't provided that information.
Okay, that's great. Well, thanks, Razia. And before we finish up, there are just a few final things I wanted to mention. As always, we really welcome views and suggestions for future podcast topics. So if you'd like to get in touch, we'd welcome hearing from you. In particular, I'd be interested to hear from any HR directors, senior HR practitioners, or innovative employers who would like to participate in future podcasts and share their thoughts with our listeners. So if you'd like to come on the show and talk about your experiences and what the current challenges are for HR, whether in general or in your specific business sector, I'd be really delighted to hear from you. Simply get in touch with your regular Taylor Vinters contact, or if you're new to our firm, you can contact me directly on dominic.holmes@taylorvinters.com. Razia, many thanks for joining me on this podcast.
Thank you, Dom. It's been a real pleasure.
And finally, don't forget to subscribe for free via iTunes if you can, so you don't miss any future episodes. Just search for Taylor Vinters in the iTunes store. Next month, I'll be joined by another member of the Taylor Vinters employment team to discuss more practical HR issues. You can access all previous editions of this podcast via iTunes, the Taylor Vinters YouTube channel, or by clicking on the ListenIn icon on our homepage, where there are direct links to the web pages of all the presenters. For those of you who are active on social media, you can also find me on LinkedIn and on Twitter @DomHolmes147. Thank you for listening in to HR ListenIn.